In this lesson, we're going to talk about the Eighth Amendment, the right to privacy, and then selective incorporation. So the Eighth Amendment prohibits excessive bail, okay, so that fine that is imposed in order for you to get out of jail while you are awaiting trial, and cruel and unusual punishment. So cruel and unusual punishment is usually understood to be punishment that is torturous or barbaric, or any punishment that is excessively disproportionate to the crime that was committed. However, there have been legal challenges to the death penalty, okay, often based on the Eighth Amendment, based on that idea that the death penalty would be considered cruel and unusual punishment. However, the Supreme Court has held that the death penalty does not violate the Constitution, okay, even though the United States is one of the few countries in the world that does still allow capital punishment or the death penalty. All right, but it has imposed some restrictions on its imposition. So, for example, the death penalty has been held to be cruel and unusual when applied to defendants who were 18 years of age or younger at the time the crime was committed, or when it has been held to be cruel and unusual when applied to defendants with some sort of intellectual disability. All right, so moving on to the right to privacy. So the Bill of Rights does not explicitly contain the word privacy, but the Supreme Court has affirmed the right and applied it to several areas, including birth control, abortion, and sexuality. All right, so first let's start with Griswold v. Connecticut, and this is a case that was decided in 1965. So in this case, the Supreme Court is going to overturn a Connecticut law that prohibits the provision of contraceptives and medical advice about contraceptive techniques. So in this case, Estelle Griswold, who is the executive director of Planned Parenthood in Connecticut, okay, is going to be convicted on providing birth control information to married patients. Okay, so that is how this case comes about. So the issue here is, does the Connecticut statute that outlaws birth control violate that fundamental right protected by the Constitution? So the court does find this Connecticut law that outlaws birth control to be unconstitutional. Okay, so the court really has a problem here, though, because nowhere in the Bill of Rights does it say anything about the right to privacy. However, the court is going to say that even though the Constitution does not specifically list the right to privacy, that the Ninth Amendment reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage of others retained by people." So they're saying that the Ninth Amendment is going to hold unspecified fundamental rights, so that the right to privacy is going to fall in as one of those unspecified rights. So this is really the first time that the court is going to say that the Constitution is going to protect that right to privacy to make decisions on things like birth control. All right, and next we're going to talk about Roe v. Wade. And before I get started talking about this, I want to make sure that you understand that Roe v. Wade is not a case on whether or not abortion is right or wrong. Roe v. Wade is a case on, does a woman have the right to privacy to make decisions about abortion? So in Roe v. Wade, Jane Wade, which is a pseudonym, her name is actually Norma McCorvey. She is going to file a lawsuit against Henry Wade, who is the DA of Dallas County, Texas, challenging a state law that makes abortion illegal except by a doctor's orders to save a woman's life. Okay, so Roe is going to allege that the laws were unconstitutionally vague and are going to abridge her right to personal privacy, so her right to make that decision about abortion for herself. So the question here is, does the Constitution recognize a woman's right to terminate her pregnancy by abortion? Okay, so does that Texas law prohibiting abortion violate a woman's right to privacy? All right, so the court is going to rule that the Constitution protects the right of a woman to have an abortion without excessive government restrictions. So under that 9th and 14th Amendment, the constitutional right to privacy protects a woman's right to an abortion, but it can be regulated or restricted by the government in the second and third trimester. So what the court says is that during the first trimester, so during those first few months of pregnancy, states are not allowed to regulate a woman's decision. That is her right to privacy. However, at the end of the first trimester, okay, the court is going to hold that the state is going to have a legitimate interest in protecting the health of pregnant women and potential human life. So beginning in the second trimester, abortion can be regulated. State legislatures have since passed or placed restrictions such as parental consent for minors and prohibiting late-term abortions. So after the beginning of the third trimester, the state's interests become sufficient enough to restrict abortion to protect the developing fetus. Okay, so it protects a woman's right to privacy to make the decision about abortion through that first trimester. So states can't make any laws concerning abortion at the beginning. However, they can regulate abortion after that first trimester. All right, so quickly, let's talk about selective incorporation, or you might also see it as the incorporation doctrine. So the language of the Bill of Rights does not restrict actions of state governments and officials. However, the 14th Amendment is going to include the Due Process Clause, which restricts state governments from denying citizens their life, liberty, or property. So selective incorporation is going to be the process in which the court uses the Due Process Clause to expand the Bill of Rights to cover state laws and actions. So this is going to be the legal doctrine by which the Supreme Court has interpreted most individual liberties stated in the Bill of Rights to protect citizens against state action. So they're using that due process clause. So state governments can't deny citizens any of those liberties in the Bill of Rights. So some good examples of this would be McDonald v. Chicago. Okay, so that is the case where they are going to apply the Second Amendment to the states. So remember, in that case, there were ordinances in Chicago banning the possession of or ownership of handguns. Okay, so the court is going to rule that the city or state is not allowed to ban the ownership of handguns based on the Second Amendment. So that is incorporating the Bill of Rights to the state governments. The other example here is Gideon v. Wainwright. So that is the case where Gideon did not have an attorney and state law did not grant him one. So he is going to be convicted, and the court is actually going to rule in his favor and say that states have to provide defendants with an attorney, that is part of their Sixth Amendment right, that it is a fundamental right. So selective incorporation is going to be that process in which the court is going to use the Fourth Amendment and that due process clause to make sure that state governments aren't denying citizens any of their rights, so life, liberty, or property. And that is where we're going to stop.